Good evening, ladies and gentlemen. This is the meeting of the Board of Adjustment of the Municipality of Anchorage. It is May 18, 2016, and the first order of business here needs to be the call to order. Madam Clerk?
Barry Puccio,
Here.
John Haxby,
Here.
Robert Stewart.
Here.
Also present is Julia Tucker, Board Counsel, and Lisa Slusner, Deputy Municipal Clerk. We have a quorum.
Thank you, and I should state that this is not a meeting of the full Board of Adjustment, but only of the panel that is scheduled to hear Appeal 2015-2. All right, you have looked at the agenda. Is it to your liking? Or are there any additions, changes, deletions, modifications that you desire?
None.
No?
I don't see any.
Okay. Seeing none, the agenda stands. There are no minutes of the previous meeting here. There's no old business. Really the only matter for discussion is what to do with Appeal 2015-2. And before we get into that, we need to talk about disclosure of potential conflicts of interest, just to be on the safe side. Mr. Stewart, any comments?
Okay. With the new municipal reorg that was effective for 2016, my daughter Renee is a senior accountant, principal admin officer for the planning division. And her boss is Hal Hart, the director. But she handles the budget for planning division and AMATs, plus she handles the admin support for planning division. She does not get involved with Title 21 actions or any reviews, decisions thereunder, and does not provide direct staff support to either AMATs or the planning and zoning. So that staff support is provided by planners or the director. So I don't see that there's a conflict, and because I do not have contact with my daughter regarding any Title 21 Board of Adjustment cases.
Okay. Mr. Haxby,
I have
anything to disclose?
no potential conflicts.
Okay. And I should state for the record that I don't have any conflicts either. What brings us here before us? Yes. I've been advised that I need to make a ruling on your disclosure statement. I do not think that on the basis of the description of the relationship between your daughter's job and what the board does, that there is a conflict here. And so I don't
But
think
there was
that you need
appearance,
to
that's why I raised it.
excuse yourself. It is good, however, that you're disclosing this so that everybody is aware of that situation. Okay? So what brings us here before us today is not a full-blown hearing on the appeal, but rather certain documents that got the ball rolling for this, and it started with DOTPF's letter of April 26. My letter to panel members of May 8, the notice from the clerk's office of May 9, the appellant's response of May 13, and then DOT's reply, or whatever you want to call it, of May 16. So these are the documents that we need to consider here tonight. The meeting was called by myself in response to DOTPF's letter of April 26, and it generated additional filing by both the appellant and DOTPF. To get the ball rolling and to have a proper discussion, we need to have a motion on the floor. So I will simply entertain a motion to dismiss the presently pending appeal in case 2015-2 because the matter is moot.
I'll make that motion to dismiss the
Okay.
appeal without prejudice.
Okay.
Board of Adjustment Appeal 2015-2, UMed Northern Access case.
Well, it would be my druthers that you leave off for the time being without prejudice and simply make the motion to dismiss.
So
Okay,
stated.
so that we can discuss the effect of it later on.
I'll revise my motion to dismiss this appeal.
Okay. Mrs. Stewart, are you going to second that motion?
Second.
Okay, all right. Now then, Mr. Haxby, it is your motion, so I think I need to give you the first shot at this to talk about it.
Well, as I see it, I would concur with your points that DOTPF and municipality have basically withdrawn. Municipalities withdrawn their support for the project and taken it out of AMATs apparently, which basically means it's no longer a priority to them. And with that being the case, the funding would not be available. And the only reason that really the state of Alaska DOTPF are involved is simply to receive the money and administer the project. So with those parties pulling out, it doesn't leave us with any case to basically rule.
Okay. Mr. Stewart?
I looked at the information that was filed by the appellant based on a notice that went out for this meeting. It looked to me like the application that they asked us to consider withdrawn, that would be okay for a finding, but to me, for us to say it's no longer valid, I think that goes to the merits of the case. So to me, that's not something that we could do. And likewise with their request to have no continuing effect, I think that would be a decision regarding the merits of the case. And I don't think we're getting to the merits of the case. The one thing that did interest me is that when I first got into this was what I'd consider detrimental reliance by the appellant, both in compliance with the appeal perfection requirements and the appeal procedures, because there's cost bond involved, there's application cost, and then issues about whether the project may or may not restart, issues involving the what happens to the appellant fee. And I also took a look at Municipal Code 21.03.050A9, where it gives us the ability to make some changes.
You're talking about the basic appeal section of the Board of Adjustment.
Right.
Is that what you're talking about?
Make sure I got that right.
You're talking about a subsection that's entitled procedural changes.
Right.
Okay.
That
So-
seems to give us some latitude, but to me, it doesn't look like that section really would come into play unless we're discussing the merits of the case.
Well,
Well,
I would like you to focus on the pending motion.
Well, but the motion itself, I really don't believe that we can discuss a case where there is, or discuss this particular issue when there is no case or controversy to get on to the merits. So in this particular instance, it doesn't look like we have a case or a controversy. And I agree with your assessment in your letter. And I think, in order for us to deal with it, I think it needs to be dismissed at this point, because going further on, unless we get something where DOT in fact comes back into the process, and they have not, to the best of my knowledge, then I think we need to dismiss it. But my issue with just dismissing it is that there's a lot of sundry ramifications that probably should be looked at. I don't think they're within our bailiwick. I think they're probably within the bailiwick of the municipality to straighten out or handle in regards to, say, for instance, possibly within the, like within the Title 21 user guide, and I had Lisa check on that, and they have not written any Title 21 user guide. So there's no guidance beyond what we have right here, which is not very much.
Well, let me see if I can focus this a little bit more. I think it is clear from the authority that the Board of Adjustment has that we can rule only on cases and can get involved only in cases of where there is a present controversy and where there is an active application on file. Are you in agreement, or what is your thought? Has in fact the application be withdrawn? Shall it be deemed withdrawn? Because a case can only be moot if there is no application there. And it appears to me, on the basis of DOT's letter here, and I'm looking at the letter of May 16, that DOT basically says there is no, in the paragraph that they label number 1, there's no present case of controversy before the board. They're acknowledging that the matter is moot. And if they're saying, well, the case is moot, then it must also mean, it follows that they say there's just nothing pending. And we have, in effect, withdrawn the application for the time being, or it is not in effect. I don't know whether that is the equivalent, the fact that it is not in effect is the equivalent of a withdrawal, or if that is some kind of a different critter. But in essence, they are saying there is no application pending at the present time that you can, that would form the basis for a decision by P&Z and can then be appealed to your board. So it seems to me that they are acknowledging that their application for a site plan review has somehow gone away, whether by withdrawal or some other ruling, I don't know, but they seem to acknowledge that it's no longer there. Do you agree with that?
Yes.
Does that make sense?
Yeah, it does.
I would look at it in terms of, I think we have to deem that it has been withdrawn because we
Okay.
don't have the direct language.
All right.
But everything we look at here indicates to me that it has been withdrawn.
Okay. If that is the case, then really any decision to do something with a pending motion needs to be based, first of all, on a finding or a statement, it seems to me, that maybe we can ask Ms. Tucker here. It seems to me that the very first thing that we need to do regarding the pending motion is that we need to have some kind of a statement there that on the basis of the apparent withdrawal by DOT and PF, as disclosed by their correspondence, we find ourselves in a position that there is no case or controversy. Does that make sense?
It does, to me.
Would it be logical,
Well, I
Ms.
think-
Tucker, for us to include a statement that,
Yes, I think both. I think there are two statements. I think that Mr. Stewart has suggested that there be a finding that on the basis of the DOT PF letter dated April 26th,
And May
that
16.
that the application is deemed withdrawn. And then a secondary statement that would be, that on the basis of those two letters that you just mentioned, the Board of Adjustment, has no case or controversy on which to issue a decision.
That should be the conclusion, right?
Yep,
That would be.
Okay.
period.
Should we incorporate that into the pending motion, or should this be a separate issue? I must tell you, I haven't thought about this procedurally.
Well, I think that procedurally you have a motion
To dismiss,
to
yeah.
dismiss.
Can we simply amend it?
Yes. Yes, that works for you.
Well, I have.
Can you reread the new motion?
I think
then?
that maybe, what the motion could be, is that there's a motion for the board to issue an order of dismissal. And that, based on your conversation here, that the order of dismissal will include a finding that on the basis of, the DOT PF letters dated April 26th and May
16.
16, the application is deemed withdrawn, and the conclusion is that the Board of Adjustment has no case or controversy upon which to issue a decision.
Motion amended as such.
No, I still have
Mr.
some.
Stewart?
Those are good. I like that.
Okay, all right, so you second that amendment?
Do you second
Any-
it, Bob?
Yes, he did. Okay.
Discussion.
Mr. Hagsby?
I agree.
Okay. Mr. Stewart?
The only thing that I have that bothers me is that all of these ramifications of just pure dismissal will have on the appeal process and what has been done so far.
Well, what bothers you?
If it's dismissed, just pure dismissal, if we say it's the pure dismissal, does that foreclose any actions by the appellants to look at the ramifications of what has gone on already in perfecting and in appealing and dealing with the municipality?
Well, it seems
Yeah.
to me that, unfortunately, the code isn't complete enough on this, because it does not
No.
address the issue of an applicant withdrawing the application. When you
You're
look
right.
at site plan review, and there's a whole section on site plan review applications, they all say, and P&Z will make the decision, and then the applicant has 24 months to carry it out, and if he doesn't, he can ask for an extension of time, and it talks about all of those issues, but it contemplates, I assume, that an applicant, if he doesn't want to go ahead, he just doesn't go ahead. But it does not contemplate a situation where the applicant simply withdraws the application altogether. You see, and that's why this is not addressed in the code, and that's why what you are coming up with is really left out in the dark. But I don't think that's for us to worry about, quite frankly.
Not
I
our
don't think we
decision.
should. That is not our decision. The only thing I can think of is here to accommodate the appellant, and I want to talk about the cost issue a little bit later, so leave that out for the time being. But to accommodate the appellant to do what also the appellee has said, there should be a dismissal without prejudice. And so it seems to me that a further, and whatever that means, I mean, without prejudice, what in the world does it mean in the context of this case? I must tell you, I don't know. But at least it's an indication by this board that if there should be a revival of the application later on, somebody needs to look at this and say, here are the appellants that have gone through all this trouble, and they should not be foreclosed to incorporate by reference what they have done before, or be given another shot at it, or whatever. I think that's about all we can say that the term without prejudice means here. There's no other definition. It doesn't exist in the code. But I think it indicates our intention that the applicant should not be penalized, that the appellant should not be penalized here if this is revived. Okay? And so I would, just one second, I would move to amend the motion by adding the words without prejudice.
Second.
Yes, Ms. Tucker.
In listening to the conversation here, and the concern about the appellants, one of the things, for purposes of discussion that you might want to consider, is exercising the authority that the board has under new Title 21, since this appeal was filed under new Title 21, under 2103-050A9, which is, allows the Board of Adjustment to relax or modify procedural rules. So I'll start with that one, because it also goes on to the cost question, which I know that the chair would like to take up later. So in terms of procedural rules, you could include in the order that the appellant be notified be notified upon the refiling of this application and or the filing of a new application for the same project. And then when the chair chooses to talk about cost, we can talk about a waiver of the appellant's fee should a new appeal be filed. I know that the documents that the board received requested refund and some other things, and the chair's going to talk about that. But it seems to me that the board could look at it slightly differently when you get to cost. But if with prejudice, I think that it's going to automatically be with prejudice if the appellants don't have any way of knowing. I mean, de facto prejudice, not written
not
in
legal,
law.
yeah.
If the appellants have no way of knowing that a new appeal has been filed.
Would that be effective? I mean, is that enforceable if we suddenly include such a provision?
It says
In the order of
procedural-
dismissal?
Procedural changes, that's the name of that's the code title here, procedural changes. And certainly as you, as chair here, have described so eloquently, we have a procedural change here that is not contemplated in code.
Yeah.
And it says upon timely application. I think that the board is authorized to consider the letter that you got back as a timely application, and to include
Yeah.
that in the order. And why, if it's included in the order, then why wouldn't it be followed?
Okay, so what you're suggesting is that if the motion to dismiss this is approved by this board, that there be a provision added in some fashion that any revival,
That
in the
appellants
event
will be-
of revival of the present site plan review application, or upon the filing of a new site plan review for this project, whatever the name of it is here, the Northern Access Project, that the appellants be notified. Is that what you're saying?
Yes.
Okay. All right. So let us first deal with the pending motion.
May I bring something up here quickly, as long as we're discussing this?
Yes.
If the application has been deemed withdrawn
Yes.
by State of Alaska DOTPF, then in order for them to do it again, they have to apply to the Municipality Bankruptcy Planning and Zoning Commission. It's gonna be an entire.
Well, to the department.
to the department.
Yeah.
It may come back, but if it comes back, it's gonna be under a new application.
Not necessarily. That's the great unknown. Can they revive it? Can they revive the current application once it has been withdrawn? I don't know. The code
Well,
doesn't address that issue.
Ed, I think under the Planning and Zoning Commission, if the application's been withdrawn, I believe that they would have to reapply with the Planning and Zoning Commission, triggering notice, triggering public, just, time for public comments, stuff like that. I think that's a requirement.
Well, I'm not sure what you base that on. It isn't in the
Experience.
code. Well, it isn't in the code, and so I'm not sure that's true. But regardless of whether it's true or not, all we are trying to make sure is that these appellants here, in this particular case that is still active right now, that they've been notified so that they can participate if they wish, regardless of whether there's a revival of the blending of the original application or whether there's a new one there. That's all we're trying to make sure. Ms. Tucker.
Also, I think it might be helpful to think of it as Mr. Stewart had suggested, that for purposes of the Board of Adjustment considering the appeal, the Board of Adjustment is ruling that the application is deemed withdrawn. I'm not clear, because the code's not clear, that Planning and Zoning and the Planning Department will deem the application withdrawn.
Well, it's not up to us to decide the law or the code. They let them write
That's
the law and the
right.
Yeah.
code, and
That's
all we're
right.
doing is
And-
ruling on what we got, and we got nothing.
And so follow, stay with that, so keep with that thought. Then, the question that you brought up, certainly if the Planning and Zoning Department, or the Planning Department and the Planning and Zoning Commission deem the application withdrawn, and everything that you said prior to my comments would of course be true. They'd have to file a new application, there's new notice and stuff like that, but what if they don't? What if they say, well, it's fine for the Board of Adjustment to consider the application withdrawn for their purposes, but for our purposes, we have a revival thing that we just now put in the book of, what was that book that you looked up?
The Title 21 guide.
Yeah, the Title 21 guidance, and so, we're gonna
User guide.
deem it revived. And so I think it's for that purpose that you wanna make sure that there's a connection there, that without tying hands or without, just as you said, the board here can only do, it can't make a decision
Nope.
under the guidelines that it's given here, but it may not be able to tie certain decisions by other authorities, and therefore, what's being suggested is that you make sure that at least the appellants, should that get revived, if we don't know,
So how,
that appellants get notice.
so how do we do that?
Well, we simply add that.
Yeah, then in
And
the order, and it's
what does it do? Does it go back to who? Where does it go? Who's responsible for it?
Well, presumably it would be the department,
Which department?
planning department.
and planning and zoning, because they would have to hear a new
And-
application.
Really? You just told me that they may not.
Well, we want to be sure that in the event of a revival, that these folks here get notice of the revival. You see, that's all we are trying to make sure of. And by giving the direction, I would suspect that will carry some weight. And if they don't get notified, and there's some detrimental effect of that they have a leg to stand on to complain.
What are they gonna do?
Okay.
Are you gonna record it
Who knows?
against the property that's not being developed?
No, we're not talking about recording
No, but
anything.
how do you, Baron, you know as well as I do, that you're gonna go through 18 employees through the Planning and Zoning Commission, or
Well-
Planning and Zoning Department, and this thing's gonna get lost.
No, I'm not sure how it can get lost, because whatever decision we render gets sent up and down the chain anyway, you see. And so the order of dismissal will get sent up and down the chain just like a regular decision would be.
Right, but who's gonna be in charge of that one sentence that says, if it comes back up again, notify these folks?
Well, that would be planning and zoning at that point, P&Z Commission.
And how do they track that? How's that tracked? I mean, how do you, literally, you got 15 people that are gone next year,
No.
and then it comes up next
No,
year.
that's the department's job, to track that sort of thing.
Yeah, the head of the
Yeah,
planning
it-
department
it
is
has
still
nothing
the
to do with P&Z.
secretary to the planning and zoning commission.
Okay.
And
Let us get back here. First of all, let us get back to what's on the table here. I filed, I moved to amend the currently pending motion by adding the words "without prejudice."
I second it.
Okay, and that's been seconded. I think our discussion makes clear that we do not want the appellants to suffer any detriment here by virtue of the fact that we are dismissing it today on the basis of DOT and PF's withdrawal of the application, and that's all that statement will indicate. Okay, so that's why I intend to vote in favor of that amendment. And I take it, Mr. Hagsby, you've seconded the motion, you're in favor of that as well,
I am in favor.
correct? Mr. Stewart, any further discussion?
No, I plan on supporting that. I think we've done the right thing.
Okay, so then, having heard all of us here, I will simply direct that the motion be deemed amended by inclusion of the words "without prejudice." Then we come to the issue of the notification. And notification of the appellants in the case of a revival of this case by any means that we cannot fathom, that we cannot foresee, simply may add the statement, an additional sentence, that in the event of a revival of the current application for site plan review, the appellant shall be notified. And I would move that that sentence be included in the motion.
And what about a new application? That's not.
Well, new application, they get notified anyway.
Okay.
So I don't think we need to worry about a new application. I think we only need to worry about a revival that somehow does not trigger the full public notice process. Okay? Anybody willing to second that?
Second.
Okay, has been moved by myself and seconded by Mr. Stewart. Any further discussion regarding this matter? Mr. Hagsby, anything you wish to bring up regarding, we are talking strictly about the amendment requiring notifications of the appellant in the event of a revival of the present site plan review application.
If the DOTPF deems their application withdrawn, then by their own standard, they have to reapply. I see it as a moot point. I don't see it as necessarily as our requirement to put a further stamp on it, saying you shall do this. That's just me.
I don't know. We know, for example, I've read in the paper today that there is another attempt being made to fund this. If that should go through the legislature, and then DOTPF looks at this and says, wow, do we now revive the original one, or do we have to file a new one? I don't know the answer to that, and I simply want to be sure that if somebody says, yeah, you can revive this thing, it's basically the same thing as what's pending before, I want to be sure that these appellants get notified. That's all. That's all we're saying. I agree with you. The likelihood is that they have to file a new one. That's the likelihood, but we don't know.
But I think that determination is going to be made not by DOT on what they file. It's it's gonna be made by division. of
Planning and zoning.
Or planning and zoning commission, yeah.
And we have no clue one way or the other.
No,
we don't know which way.
on there.
And that's why we want to be sure that if there's a revival, that they get notified.
Fair enough,
Okay?
fair enough.
Anything else, Mr. Stewart?
Nothing.
Okay. All right. Ms. Tucker,
Yes.
worthy counsel, anything else that you wish to add here at this point?
Were you going to move on to costs?
Are we gonna
That-
approve the motion?
We have to
Well,
We
approve
have to
it.
vote on that.
Well, wait a minute. Let us talk about the cost issue for a bit, because that may or may not impact the pending motion. It's clear to all of us here, I think, that the appellant went through a significant expense, let alone the effort to get here with the appeal and where they are today, and we are today. And I, for one, am not pleased that DOTPF waited this long after the mayor sent in his request in December, which time this appeal was pending, that instead DOTPF waited another 5 months to tell us now, in view of the mayor's position here and the MOA's position, we're not going to pursue this. They could have done this promptly after the receipt of the letter from the mayor in December, at which point the appellant would not have been put to the significant expense of monetary expense and time expense to get to where they are today. Nonetheless, it is my view that the code does not allow us to do a whole lot here, because when we look at, there is a specific section, and I spent my time going through this, I want you to know. There is a section here, and I'm specifically looking at 210305 034C, talks about fees and costs that have to be paid by an appellant. And then in little c, the last sentence says, all costs and fees shall be returned to the appellant if the decision of the lower body is reversed in whole or in part. What that indicates to me is that if the Board of Adjustment enters a decision that reverses in part or in whole the decision of P&Z, then the appellant gets a certain amount of money back. But that case we don't have here, because we are simply about to dismiss the case. So it is my view that there is, perhaps unfortunately, no provision in the code that allows us to redirect or to direct the clerk's office to refund the money. That's unfortunate, but that's how I see it. Perhaps the appellant has some additional way of doing this by talking to an assembly member, and perhaps, I don't know how many dollars are involved, so let's not talk about it. But I view the matter as being beyond our control to direct the refund of money. Any thoughts on this, Mr. Haxby?
I concur.
Mr. Stewart?
No, I agree with you. The costs are set forth in regulations, and this doesn't allow us to change them.
Yeah, and, you know, I'm not sure we're talking about attorney's fees in any way. You know, lawyers tend to talk in terms of costs and fees, and so I view those as two separate matters altogether. There's absolutely no provision in code to award fees or to do anything of that sort, so I really don't think that we have any ability to provide assistance here. So for that reason, it is my view that we should not address the issue of costs at all. Ms. Tucker?
Just so that you're making an informed decision, there is a provision now in new Title 21 under 21-03050A9 that is different than the provision that you and this is a new provision that is not in old Title 21, because this application is in new Title 21. And it is totally permissive, but this is what it says: procedural changes. Upon timely application and for good cause shown, the Board of Adjustment may relax or modify the procedural rules or the rules relating to costs contained herein for the orderly transaction of appeals before the board. And so it doesn't mean that you need to do that or that you are required to do that, but I think it would be a mistake to say that there is no provision that would allow you to do it. As I suggested, one of the ways that you could address this, maybe, if the board was so inclined, to couple this with that notice provision that you have under consideration, and simply state, rather than any other adjustment, to say that in the event a new appeal is filed by this appellant on a revived or new application for the same project, that the fees in that case, the filing fees in that case, shall be waived in consideration of the work that has been done here. Then you don't have to do a refund, but at least you're taking into consideration that fees were already paid once for an appeal, only to have the appellee yank the application and move on.
Okay, Mr. Stewart.
Are you sure that this particular subparagraph 9, procedural changes, are you sure that that does not apply just only to when we get to the merits of the case?
I see nothing in here to restrict that to a decision that's reached on the merits. We don't have a guidebook that talks to us about what
Yeah.
we're doing here. And sometimes in code, you can't project every single thing, but I tell you what we do have a procedural change. All of you have acknowledged that this
Yes.
is a procedural change.
Okay,
And
so we've gotten
just
by
a
that
common
issue.
sense approach
Gotcha.
there would allow me to counsel
Yeah.
you in the way I have. And
Yeah.
again, it is absolutely permissive.
I think that's true. What supports that interpretation is that it says at the end of that sentence, for the orderly transaction of appeals before the board. And I think that would impact, or that would give the leverage to say, if there's an appeal necessitated by a new application that is basically for the same project, the fee should be waived. I could support that, if somebody wants to make that motion.
I don't, you see, I just don't know whether or not, you say that it's permissive, but our actions are based upon coming to a conclusion, trying the case. Then I think it is permissive. And unless we're actually trying the case on the merits, I would be hesitant to do it.
Any thoughts, Mr. Stewart?
I'm thinking that when we're discussing this without having all the facts in front of us about how the costs are set and why there's certain costs that are set up, it seems like, to me, like we're taking away part of the responsibility in this particular case without having that in front of us, taking away that responsibility from the municipality.
Mr. Chair, can
Yes. Ms. Tucker?
and I'm not an advocate for the appellants or the department, which happens to be the clerk's office here. I think that you're allowed to think about what the scope of your amendment without prejudice means. certainly, there is prejudice if a applicant goes so far down the path without telling the appellant or the department that their application is virtually withdrawn or that they're not going to participate. And the applicant in this appeal goes through all the work and effort that they did here, only to have the applicant, the appellant go through all that work, only to have the applicant turn around and file another appeal so that the applicant has to redo it. So I think that's sort of a equitable. I ask you to you know, you're allowed to consider those equities, I guess, as my counsel. I'm not saying that you have to, I'm just saying that.
Let me ask,
Darren, may I ask?
just one second. Lisa, tell us what the fees were. Do you have any idea what the appeal fee was?
Yes.
What are we talking about here?
May I?
Yes.
Pass this number?
So, from what you've handed me, Lisa, apparently the notice was $1,080. It was a cost bond of $50. So we're talking about appeal fees of $1,130, and then there is approximately $1,500 in round figures of the preparation of the record. I view those as two different matters altogether in any event. So I'm very reluctant, and frankly, the more I'm thinking about it, I know that our trustee lawyer here tells us we have this authority to do that. I must tell you, however, I'm not in favor of doing that, and so if somebody were to make a motion to that effect, I would not be supportive of it. I think we need to leave this. It's very unfortunate, as I said before, that DOTPF waited so long and that they didn't do anything more appropriate. And it's clear to me that a portion of the costs that were incurred here were directly the responsibility of DOT and PF for not doing a proper notification in a more timely manner. So, having said all that, I'm not in favor of doing it. But, as chair, obviously, I'm here to listen to motions and to amendments of current motions if there is such a desire.
I would make a motion not to address the issue of costs.
Okay, well, before you do that, you would make the motion. We have a pending motion on the floor, and the only thing we can do, it seems to me, unless Ms. Tucker tells me otherwise, the only thing we can do is to amend it, the pending motion, and if we don't amend the pending motion, it just dies. The issue dies.
Yeah, I agree.
Okay? Mr. Stewart, any thoughts on this? You're always the one who comes up with these incredibly
Well,
innovative code sections here
That was
that
politically
nobody
correct.
has thought about, but that are in this gigantic volume here.
well, I did see that, but, it threw me for a loop when I saw it because it wasn't in the last one.
Yeah.
So
Okay.
this is the first impression case, and I feel comfortable with the way that the motion is now.
Okay.
Rather, if we amend it, I get more uncomfortable because we're dealing with things that I think could be negotiated out or worked out within the municipal
Yeah.
confines.
Yeah. All right. Ms. Tucker, any additional comment regarding this matter?
I would suggest to the board, also that unless you, do or amend something in your motion, that you haven't foreclosed the appellant making an application, for a fee adjustment in the future, should the appeal be, filed under this provision. So, you know.
Yeah.
Yeah.
I just,
Yeah.
having the discussion, it's a first impression, I needed to give you all my
Yes.
thoughts about it. But just know that.
It doesn't
that-
foreclose making that motion at some
That's
later
right.
point.
Right.
That's right,
Yeah.
because you
And-
have
Yeah.
said with, you know, without prejudice, and the code
Yes.
says upon timely application. And if, it would be reasonable in my view to think that timely application would be once they have notice.
That would
Either
be-
of a new application or of another to say, hey, you know, this is what happened 4 years ago.
That would
we
be up
did
to
this
the
and this and
appellant to
this."
bring that up.
Yeah,
Yeah.
Yes, that's what
Exactly.
I'm saying.
Let's let
Exactly.
them bring it up, and
Yep.
then we can decide on it at that point.
okay, all
Well,
right.
and then you've got the opportunity, if that's the case, of the other parties, the appellee and the municipality, to come forward with
Weighing
their
in.
own.
Weighed in
Exactly,
on the application.
exactly.
Mhm.
So I think, very good, I like this closure on that issue. All right, then let us come back to the main motion as amended at this time. And it is a motion to dismiss the currently pending appeal in case 2015-2 without prejudice and with the direction that in the event the case is revived, that the appellant be notified.
Here.
Period. Now, there are additional matters there that we have addressed, and one of them is a finding that all of this is based upon the application by DOT and PF for a site plan review having been deemed, or being deemed withdrawn, and our conclusion that for that reason, the appeal is moot. And it seems to me that when we draw this up, that those two, the finding and the conclusion, need to precede the motion.
Right, I think the wording that you used there was also that there's no case or controversy, and
Correct.
I think that's
Yes.
in my notes for that conclusion.
Okay. Are we ready to vote on this issue? Anything else before we vote that should be brought up? Mr. Hagsby?
No.
Mr. Stewart?
None.
Ms. Tucker?
No, sir.
Anything else? All right, we are then ready to vote. Madam Clerk?
How do you vote? Aaron Guccio,
Yes?
Robert Stewart,
Yes.
John Haxby,
Yes.
And the record should reflect that the motion passed with a vote of 3-0. And looking at this, what we usually do is that our esteemed counsel will draft something, or Lisa will draft something, and it will come to my attention, and I will review it, and if it conforms with what we have decided here, I will simply sign it.
So we
Okay.
don't have to meet again.
We do not
Could I
have to meet
make
again.
one further motion?
Yes.
I'd like to make a motion to vacate our hearing of August 4th.
Thank you so much for bringing this up. That's absolutely appropriate, and I'm very appreciative because I would have overlooked that. So it's been moved and presumably seconded by
Second.
Mr. Stewart that the hearing date of August 4, 2016 is vacated.
No.
And, yeah, the hearing date is vacated.
Right.
Yes, sir.
One other thing, when we sign the findings, we're gonna put the 30-day appeal requirement to Superior Court. Otherwise, there's no review of what we've done.
I think I think that's absolutely, even though it is a procedural order that the chair
Administrative
can
due
sign,
process.
I
I
think
think it
that
needs to
all
be.
decisions by code have to include that.
I
and
think
would
that's
intend to
absolutely
include
true.
it. So thank you.
Yes, thank you for alerting us to that.
Okay.
I appreciate it. Okay, we are, however, talking about the motion to vacate the hearing date of August 4th. Has been moved and seconded.
Oh, I'm sorry.
Any further
I just-
discussion regarding that matter? No? I'm in favor of it as well. So it appears that that motion carries on with all of us in favor. So, anything further?
No.
Anything further? Oh, we need to allow audience participation. But as always, the audience that is sitting there may not discuss the pending case. So I'm not sure what they are supposed to be commenting on, other than what this board does, or what we're wearing tonight, or what have you. Is there any such discussion? No? Yes, sir.
Just like to thank you for your service.
Well, we all appreciate that. Thank
You
you.
can
I
take
want you
that.
to know
Thank you.
that we do not take our jobs lightly, and that we spend time on it, and that we think about these things. And sometimes the result may be in your favor, or sometimes they may not be, but I can assure you it is always well considered. So thank you for your comment. I appreciate that. All right, there being nothing further, the meeting is adjourned.